I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what today is. But it's exactly what you make it. So please don't go wasting. And I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. Of what a good day is. What a good day is. And that's exactly what today is.
All right, we are in the building. Good morning. Shout out to everyone who's in here. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. Oh man, we up in here looking all crispy and clean on a Friday. Welcome y'all. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host ClassE, and we're looking forward to having a great show today. Y'all make sure you check out the Patreon if you haven't yet. Patreon.com/ClassEbeats. But before we get into our show, we're talking about YNW Melly. Drake finally responds to UMG, and we've got some updates when it comes to Yella Beezy and the Big U federal indictment. It's getting crazy today. I gotta say what's up to the people though, man. Shout out to everybody who's in the building. I see y'all up in here. We've got my awesome, amazing Amy is up in here. Shout out to Amy in the building. We got A Fitz, Les Cleaver, my guy, already dropping the super chat. We've got Derek in here. Good morning. Trisha is in the building. Tatum, Jay Buckmaster. What up? What up? We've got Michi. Mo Mac is in here. Oh, hold on. I missed somebody. Oh, we got Nisha in here. Good morning, Nisha. Tatum. We got Don, Leonard. We got Yellow Boy is in here as well. Finally caught the live. Good to see you. Also, Rice Street's in the building too. Always good to see Rice Street in here. I am not going to waste any time. We're going to go ahead and get right into the show. If y'all could do me a favor, it takes 2 seconds. It's free, and it really does help the channel continue to grow. If y'all could, make sure you like the video on your way in. All it takes is a click, and it lets the YouTube algorithm know that y'all are enjoying the show, and it shares the video out with more people. And not just YouTube, wherever you're watching. I know we're streaming over on X, we're streaming on YouTube, we're streaming over on Facebook, we're everywhere. And thank y'all for dropping the ones in the chat too. All right, let's go ahead and get into it because we have a lot to get into today. And hopefully y'all are doing well. Let me know what y'all are getting into this weekend too. Got a busy weekend with kids and all, you know, softball, baseball, everything going crazy. But I'm looking forward to getting to the show with y'all. So we're going to talk about what's going on with YNW Melly. Now, we know this YNW Melly trial has been held off for so long. First trial, there was a whole lot of issues. Now we're still having issues leading up to the trial. As we know, Raven Liberty, she got an email from Apple saying, hey, by the way, your account has been accessed by Broward County. And Raven Liberty said, what's going on there? Lets the rest of her legal counsel know. come to find out, the Broward County Police Department was trying to get access to her phone records to find out some of the communication she was having over text message. Then there was a back and forth. They wanted to know, the defense wanted to know why they were doing that. They had to struggle to get the affidavit, and it was just a whole mess. So now we're still in this fight, the back and forth between the defense and the prosecutors. And we've got a recent update here where YNW Melly is trying to take a stand and fight for his rights just as an American citizen. So we're going to go ahead and get into it here. Make sure y'all like the video on your way in, and shout out to Bryson over on X, Bryson Boom Paul. He's the one who posted this document. Y'all make sure you go follow him as well. He's been doing an excellent job covering this YNW Melly trial. He says YNW Melly's attorney, Daniel Aronson, filed a motion to reveal the state's intrusion on defendants' right to due process, client credibility, attorney-client relationship with Broward County Clerk on Monday afternoon, right? So we got this 9-page document. Melly and Aronson argues that the state's handling of Attorney Raven Liberty's Apple account data constitutes a severe violation of due process and attorney-client privilege, necessitating immediate court intervention. All right, so we're going to go ahead and get straight into the document here. And again, shout out to Bryson for posting this as well. So we have a motion to compel discovery in the alternative motion to reveal extent of the state's intrusion on the defendant's right to due process. Client confidentiality and attorney-client relationship. What are they saying? Comes now the defendant by and through undersigned counsel and moves this honorable court pursuant to Rule 3-190 Florida Rules of Criminal Procedure to issue an order requiring the state as follows. Here's what they want the state to do: to return all property seized from defendant Jamel Demons regarding Attorney Raven Liberty's Apple accounts. So text messages, I'm guessing there, phone calls. Provide copies of all material in the state's possession obtained from Attorney Raven Liberty's Apple accounts. Provide notice to the defense of any and all documents received that may have a bearing on the attorney's client privilege. Provide the protocol that was used to segregate the information provided. That's going to be key, because the state was already saying in the first place, well, we can't tell you why we're looking at this information. We can't tell you why we need this information. We just need to get it. And you're going to have to figure it out. And if Melly doesn't like it, then he can drop you guys as counsel. We're not going to tell you exactly what we were looking for. And the defense obviously had a problem with that. All right, so let's go back. Provide the protocol that was used to segregate the information provided to the state under the search warrant for Attorney Liberty's Apple accounts from the prosecutors currently prosecuting the defendant in this cause. A list of all witnesses who were involved in obtaining the search warrant for Miss Liberty's Apple accounts and that reviewed any evidence seized under said search warrant. They had to fight to get access to the search warrant. And any and all documents, including search warrants, affidavits, police reports, and findings in relation to the search warrant seizure and review of Miss Liberty's Apple accounts. As grounds for said motion, the defendant states the following. On February 8th of 2019, the state filed an indictment charging the defendant with 2 counts of first-degree murder. On March 5th of 2019, the defendant entered a plea of not guilty, demand for a jury trial, and demand for discovery pursuant to Rule 3220 of the Florida Rules of Criminal Procedure. On April 16th of 2019, the state filed another notice of intent to seek the death penalty. It's in Florida. They don't play. On October 17, 2023, the state filed an information charging the defendant with tampering with a witness in a capital felony, directing the activities of a criminal gang, solicitation to criminal tampering, and conspiracy to commit tampering. Right, they're talking about communications between Melly and somebody else who's alleged here. On November 9th, 2023, the defendant entered a plea of not guilty, a demand for a jury trial, and a demand for a jury trial under the tampering case. On January 24th, 2024, the state filed its initial discovery response in the tampering case. On December 27th, 2024, the defendant filed a motion for a hearing to determine potential conflict setting forth that a member of the defense team, Raven Liberty, was informed by Apple that on December 13th, her Apple account information had been provided to the Broward County Sheriff's Office pursuant to a search warrant. And she had no idea that they were doing this. Thank God for Apple and Apple security. Way better than Android. Just saying. On January 6, 2025, the defendant made an or tennis motion to compel the state to provide the affidavit to the search warrant. And I just went through this with y'all on Raven Liberty's Apple accounts. And the state initially said no. Judge Fiend, he said, okay, fine. You guys don't want to do it. You have to do it. And you need to do it by this date. The state came back and told the judge, no, we're not doing it. The judge said, okay, fine. Now I am ordering you to provide this search warrant and the affidavit. And the court said, Judge, that's great, but we can't do it. We're not going to do it because we don't want to. There's going to be a conflict here with the ongoing investigation and such and such. And the judge finally got his ruling in, and they had to provide this information to the defense. And the defense's reason for that, they basically said, Melly needs to know this information and what's going on because he needs to make a decision if he wants to move forward with Raven Liberty as his counsel, if he wants to move forward with me as his counsel. So that's the issue here. And the state obviously didn't want to give in at all. On January 6, 2025 of this year, the defendant made, again, motion to compel the state to provide affidavit to the search warrant on Raven Liberty's Apple account. The court ordered the state to provide the affidavit the following day, January 7th. On January 7th, this court modified its previous order and ordered the state to provide a copy of the Apple search warrant to the court to be viewed in camera on or before January 14th. Then it was viewed in camera and the judge said, yeah, there's nothing here. I don't see an issue. You guys in the state, you should be able to give this to the defense. On February 7th, 2025, the court provided all defense counsel as well as defendant a copy of the unredacted search warrant. The unredacted search warrant revealed that every aspect of Miss Liberty's accounts and every bit of information contained therein was provided to the Broward County Sheriff's Office pursuant to the warrant. The state never revealed during approximately a year's time the fact that they had in their possession the contents of Miss Liberty's Apple accounts. Of course they didn't. Only after the defendant on December 27th brought this matter to the court's attention did the state acknowledge that Miss Liberty's accounts had been sieged. And of course, because she was made aware by Apple. The state has contended that no other member of the defense team of Mr. Demons is under investigation or had any warrants issued against them. However, in a federal civil proceeding involving the defendant, attorneys for the Broward County Sheriff's Office also indicated that the defense team's investigator, Reggie Hope, has also been subjected to similar warrants. So they're lying. Surprise. On February 18, 2025, this court granted the defendant's motion to compel discovery. The state was given 20 days to comply. The state has yet to provide any discovery subject to this order. Again, we see the state acting like they're above the law. Is anyone in here surprised? The state has yet to provide any discovery subject to this order, that being all information, documents, witnesses, and evidence in relation to the search and seizure of Attorney Liberty's Apple accounts. The state's numerous times has asserted that these discoverable materials are germane to the defendant's tampering with the witness's charge. That is now part of this case. So here's their argument in closing. Although this court has been allowing them to involve itself in the determination by the defendant as to whether he would like to have Raven Liberty represent him, as the state has said, based upon the information that they have, there is a conflict. Conflict is but a small part of this motion. Rather, the seizure of Miss Liberty's Apple accounts not only raised the issue of conflict under the Sixth Amendment of the United States Constitution, but also of attorney-client privilege under the Sixth Amendment. And then they go on to talk about this more, to say they should be able to share this information with him, etc., etc. So it's a really hard situation to be in because the state has access to all this information, and it's going to unfortunately lead to delays in this YNW Melly case when this guy's been in jail for over a third of his life, which is wild to even think about. So either way, let me know what y'all think about this in the comments and in the chat. Is there going to be justice for Melly moving forward? And what's going to happen with his decision? Do you think he's still going to keep Raven Liberty in there with all this controversy that's been going on? Let me know what y'all think. And I see a couple of y'all just joining into the show too. Shout out to LTOs up in here. I see you. I also got to put some respect on my guy, Les Cleaver, man. He dropped the 5-bomb. What did he say? Thank God it's Friday and amen. It's been a long week. God bless you all and much love to all of you. Shout out to my guy, Les Cleaver in here. Please appreciate the love, Les. Thank you for always supporting. Also, Tatum just became a member. Shout out to Tatum. And welcome to the gold side. Make sure y'all go check out the members only content over there. LTO says this man's going to be 30 years old, still in Broward County Jail. I swear. God, I hope not. I hope not. He shouldn't still be in there in the first place. He needs to be granted bond with house arrest. This is crazy. I just want to know what they're doing. Like, what's the big secret? I agree. Is that not insane to access someone's information or records and then they ask you why you did it? Then you tell a federal judge, don't worry about it. Yeah. Happens all the time, unfortunately. They're like, we can't tell you. We can't tell you why we access your information because it's currently under investigation. So we don't want to mess up our investigation. We don't want you to do anything shady. So yeah. Amy says, apparently they doing anything. It's true. It's true. And the judge had to tell them not once, not twice, but 3 times that they needed to get this information to the defense. Finally, he viewed the affidavit and the search warrant in camera. He said, there's nothing there. There's nothing that's going to impede your investigation. Go ahead and give this to them. They're allowed to see it. YNW Melly specifically is allowed to see it, and they reluctantly handed it over. Now they're still waiting to receive some of the documents that the judge ordered them to give, that the judge ordered the state to give. So we're going to keep it moving and get into this next update. We've got a Drake versus UMG update, and this is a fun one. Let me see, make sure I didn't miss any more of y'all's comments. When you say it out loud, it sounds insane. Yeah, it does. It does sound crazier when you say it out loud. Like, yeah, we know it's your information, but don't worry about why we're accessing it. Anyway, so UMG and Drake have been going back and forth for what seems like a year now, but it hasn't been quite that long. Either way, UMG recently, they submitted their motion to dismiss, and they said this whole lawsuit is BS. Drake is just mad because he lost the beef with Kendrick Lamar. Judge, we don't even know why we're here. This is a waste of the court's time. You need to dismiss it. Drake doesn't even have a legal basis for this. And here's why. So they laid that out, right? The judge saw that and said, fine. Drake, listen, I hear what UMG is saying, but if you're going to make any changes or updates to this claim, you need to go ahead and get that done before we move forward, because I don't know what we're doing here. Because you had a conversation with Spotify. Now Spotify's out of it. You had a conversation with iHeartMedia. Now iHeartMedia is out of it. So are you guys going to make some changes? Are you going to keep it as it is? Let me know so I can make my decision. So now we have an update here from Drake's camp. And what do they say? We've got a letter to Judge Vargas. And what do they say? The plaintiff, Aubrey Drake Graham, respectfully writes, pursuant to the court's order, ECF number 28 and Rule 5.1 of the court's individual rules of practices in the civil case, to notify the court that he intends to file an amended complaint by no later than April 16th, 2025. Okay. And then you have Drake's lawyer there who is writing this. So the question is, what's going to happen here? Is he going to say what information, if any, he got from Spotify? Is he going to say what information, if any, he got from iHeartMedia? And again, we still haven't gotten to discovery. Like Drake wants to get discovery from UMG, and UMG doesn't even want to go that far. UMG doesn't want Drake to even be allowed to ask them questions about what went on during this beef between him and Kendrick Lamar. And that's where a lot of the issue Drake is having a pushback. He's like, hey, let's just go down this process. And UMG said, no, this is silly. We don't want to tell you anything. We don't want to tell you about our conversations with Spotify, radio stations, influencers, iHeartMedia. We don't want to go down this path at all. So now we move into an actual full response from Drake and his team. And actually, let me do this a different way. We're going to, give me 1 second. I'm going to open this in this way so we can actually see it a little bit better. Here we go. So we've got another letter here from Drake, and this is actually a response from him for the actual motion to dismiss from UMG. So we've got a 4-page document here, and Drake is going to lay out why UMG is wrong about this, and he should be allowed to move forward with the discovery. All right, here we go. Dear Judge Vargas, pursuant to sections 3A, 6B of the court's individual rules and practices in civil cases, plaintiff Aubrey Drake Graham writes in opposition to defendant UMG Recordings letter motion to stay discovery. Again, UMG doesn't want Drake to start looking and digging up stuff. They don't like it. It is not the practice of this court to routinely stay discovery pending the outcome of a motion to dismiss. ECF filing number 21, and they're citing G versus Maxwell. Federal Rule 26C provides that the court may, for good cause, issue an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Federal Rule Civil Procedure 26C. Good cause is a significant element of the rule. Why? Which courts analyze by the application of 3 factors: whether the defendant is making a strong showing that the plaintiff's claims is unmeritorious. There we go. 2, the breadth of discovery and the burden of responding to it. And 3, the risk of unfair prejudice to the party opposing the stay. All right. The MTS fails on all 3 factors, and here's why. First, UMG fails to make a strong showing that the plaintiff's claims are unmeritorious. So basically, Drake is saying, UMG is saying, I don't have a leg to stand on and I can't bring this claim forward. I'm saying that UMG doesn't have a legal basis to say that I don't have an opportunity to move forward with this claim. Here's why. On a motion to stay discovery, the defendant must make a strong showing that the plaintiff's claims are meritless as to warrant a stay. Bennett versus Kumo, it looks like. And the courts have looked to whether the complaint is facially without merit. For example, a motion to stay was appropriate where the defendant's motion to dismiss was directed to the federal court's jurisdiction, where the jurisdiction could be determined readily from the face of the complaint, and where the plaintiff was unable to cite any relevant authority in support of the existence of the jurisdiction. But where it is not clear the defendant is correct, a stay cannot issue. So he's saying if it's not clear that UMG is right, then we got to keep moving forward and let Drake have his chance. UMG has failed to meet its burden. The MTS, like the MTD, ignores the vast majority of the plaintiff's well-pled factual allegations in the 237 paragraph complaint. Yeah, we didn't read the whole thing, but we got to a lot of it. UMG has failed to meet its burden. UMG's headline argument is that the defamatory material is non-actionable opinion and that no reasonable person would understand as a statement of fact. Again, even as I was reading it, looking at it objectively, I can see some issues where things might be stated as fact and pushed as fact and used as a weapon against Drake. On the other hand, it's not clear, but Drake addressed that earlier. He said, it is not clear that the defendant is right. In my opinion, he is correct here. So that was I think they cited a great case there. It's really not clear that UMG is right. It's not clear that Drake is right. So let's move forward. MTD at 11. This argument is doomed to fail and is nowhere close to establishing that the plaintiff's defamation claim is facially without merit. For one, UMG completely ignores the complaint's allegations that millions of people all over the world did understand the defamatory material as a factual assertion that the plaintiff is a PDF, as the young folks say. See generally paragraphs 167 through 187 and paragraph 94 detailing the public statements. Fair point. UMG also ignores allegations that the statements in question, and it's funny that they say this because the public statements, I mentioned this. I talked about streamers, people making videos, trying to point out certain things. It's going to be used in the document, and now we're seeing it here. UMG also ignores allegations that the statements in question and surrounding context implied that the allegations were based on undisclosed evidence and the audience understood as much. I mentioned this the last time when we were reading UMG's motion to dismiss. What did Kendrick say? Don't tell any lies about me, and I won't tell any truths about you. Now, again, this isn't on Kendrick Lamar. This isn't on Kendrick Lamar. It's about what UMG is using in this instance. And was it presented as true? That was a line in one of Kendrick Lamar's songs. So anything after that, can it be taken as true? Again, I don't know. It's not clear. So Drake should be allowed to move forward with discovery, my opinion. UMG also ignores allegations that the statements in question, all surrounding context, implies that the allegations were based on undisclosed evidence and the audience understood as much. People thought stuff was going to come out. They're like, oh, wait, Kendrick gonna get him. Wait till he talks about his daughter, his secret daughter. I guess that's over with. Wait till he talks about what Drake's been doing. Indeed, UMG effectively concedes that it has no hope of defeating the sufficiency of the complaint via its attempt to substitute the pleadings with its own factual narrative contained within a request for judicial notice of 26 exhibits. Wow. ECF number 25, UMG improperly asked the court to accept many of these exhibits for the truth of the matters asserted herein, relying on news article for the truth of statements made about the consenting meaning of lyrics, offering UMG's interpretation of the meaning of lyrics from another exhibit. I mentioned this as well. We need a detective super investigator Viverito. We need a lyrics expert. We need a beef expert to come in and actually give us their opinion on what was actually meant by this. And are these things to be taken as true? Is that part of the beef culture? How should we consider this? All right, UMG improperly asked the court to accept many of the exhibits of truth of the matters. Okay, we already got through this. None of this is appropriate at the motion to dismiss stage. UMG's reliance on Rappaport versus Barstool Incorporated fails. Okay, how does it fail? For one, Rappaport was decided on a summary judgment motion. And critically, in that case, there were no allegations that viewers of the defamatory allegations in fact believed them to be a statement of fact. Nor did Rappaport involve allegations of PDFia. I guess that's how we say it. I'm not saying that word out loud. See paragraph 191. And one of the statements deemed non-actionable disclosed the evidence on which it was based, evidence which actually refuted the veracity of the allegation. The only other element of defamation UMG challenges is actual malice. MTS at 3. UMG suggests that Drake cannot plead actual malice because the statements were not statements of fact. MTD at 18, but that is just a repackaging of its failed opinion of the argument. Fair point. UMG also misstates the pleading standard for actual malice, relying on a case from the Ninth Circuit at the summary judgment stage. We've got D versus Hustler Magazine Incorporated. UMG suggests that Drake must allege that UMG subjectively intended to convey a defamatory message. And I mentioned this before too. It doesn't seem to be the case. In this circuit, however, the pleading standard for actual malice requires allegations that the statements at issue were made with the knowledge that the statements were false or with reckless disregard as to their falsity. So Drake, they're essentially saying, hey, this type of beef has no place in the music industry and it shouldn't be pushed by a record label. Dang. And B-Row versus Condé Nash, I don't know. Here, the complaint adequately pleads that UMG knew or had reason to know that the allegations in the defamatory material, Not Like Us, were false. Paragraph 20, 70, 90, and 209. And UMG concedes that the allegations were not true. MTD at 15 through 18. And even if the plaintiff were required to plead intent to defame, he does so. UMG brazenly continued to publish and promote the defamatory material, even after Drake's home was attacked by a gunman. Oh, yep. I mentioned this as well when we covered the motion to dismiss. After his businesses were defaced, the OVO store in Canada, after the plaintiff made UMG aware of the falsity of the allegations and the harm they were causing, and after UMG knew that the public believed the allegations to be true statements of fact. Wow. Drake might have a case here. I know a lot of y'all aren't going to like it, but he might have a case. UMG also fails to make a strong showing that the plaintiff's two remaining causes of action are unmeritorious. UMG contends there is no private right of action for harassment. And then, but numerous courts have long recognized a private cause of action for harassment under the New York law. And then they cite the cases there. As to the plaintiffs, Drake's claim under the New York GBL 349, the complaint pleads a number of deceptive acts and practices through which UMG covertly financially incentivized third parties to play, stream, and promote the recording, including covert payments to a popular podcast, payola payments to radio stations, and charging below market licensing rates to Spotify. Thank you for saying this, guys, because so many of y'all in the comments, I even had someone tell me, oh, you don't know what you're talking about. They removed the payola. They've been dropped. No, they're citing it here. It's still a part of the claim. I tried to tell y'all this, so some of y'all owe me an apology. It's all encompassing. It's all a part of the issue in this big scheme Drake is saying for UMG to devalue his brand and defame him. It's all still in there. So I'm so glad they brought this back up. I tried to tell y'all this was included. Now you see it from Drake's side. Oh, they ain't done yet. The fact that Drake has agreed to withdraw and correct the street set allegations concerning alleged payments to one specific third party does nothing to strengthen the defendant's MTD. UMG fails to show that discovery will impose an undue burden on UMG. UMG fails to articulate any undue burden in responding to Drake's 18 requests for production. UMG has the burden to present specific facts as to the burden. And also, UMG claims that complying with Drake's discovery requests would require costly collection and review of large swaths of hard copy and electronic data sets. Oh, they're crying. Poor UMG. They got to go digging. I feel bad for them. It's going to require costly collection and review of large swaths of hard copy and electronic data sets, contracts and agreements and communications, and they don't want to go through it, Your Honor. It's going to be a waste of our time and cost us a lot of money. Poor UMG. But UMG has been on notice of Drake's claim since July of 2024, at which point UMG was obligated to preserve all relevant communications. It seems unlikely that UMG would not have collected or reviewed any of the electronic data in the intervening 8 months. And to the extent that UMG has not done so, staying discovery would only incentivize further delay of an investigation UMG should have undertaken long ago. Basically what they're saying is as due diligence, if someone brings claim against your business, you're going to start looking at stuff and you're going to say, dang, I need to go back through my text messages and the emails and see if maybe at some point I said something to Spotify about a discounted licensing fee. I might need to check into that. Hey, Susan, can you go through and can you have IT pull those up for me and send them to me? You know, now that I think about it, I may have been texting the CEO of Spotify at some point about pushing Not Like Us since it was doing so well. I might need to go check on that. Let me have my assistant. Hey, Karen, can you go pull up my text? Basically, they're saying as soon as this came out, UMG, they were over there going through everything. So they know what's going on. They already started this process and they're not just sitting there writing emails to Judge Vargas saying, hey, we shouldn't have to do this. No, they're preparing for war. And that's what this is. Taking UMG's claim of burden at face value, it does not come close to demonstrating an undue burden, as the burden of collection and review is present in every case. For example, UMG has not stated how long it expects discovery to take, the cost associated with discovery, or any indicator that might demonstrate why discovery will be overly burdensome. They just don't want to do it. That's the statement. Nor does UMG object to the scope of any specific requirements. True. While UMG claims that certain requests call for proprietary information, plaintiff Drake has already sent a draft protective order, the court's preferred form, which affords confidentiality protections from both parties. Interesting. So no names will be named, it seems, but we haven't seen the order, so we'll have to wait and see. UMG fails to show that Drake will not suffer prejudice. UMG fails to show that no prejudice will attend to Drake. For one, UMG does not even address the ongoing harm to Drake as detailed in the complaint, paragraphs 192 through 201. The plaintiff's injuries, Drake's injuries, accrue by the day, and Drake has sought injunctive relief. Beyond that, Drake has serious concerns about not just UMG's preservation of documents, but preservation by third parties as well. Time is of the essence, including with respect to categories of electronically stored information that are not always subject to regular business record keeping practices, such as mobile data. We talked about the text messages. For those reasons, the MTS should be denied. Motion to stay is what that stands for, by the way. Respectfully submitted, Mr. Michael G. What do y'all think, man? I think Drake has a case here. I think they're fighting. I know some of y'all are like it and don't like it and are saying they not like us. But when it comes to the business side, UMG is starting to look like they may have messed up. So let me know what y'all think about this in the comments and in the chat. Oh, I cannot wait to see what goes down with this, man. I think UMG's in trouble. I think UMG's in trouble. And honestly, I don't even want to say stuff like this, but Drake needs to be careful because he's not invincible. He's still human, and he's not UMG. UMG isn't one person. UMG is a powerhouse, and I think it goes beyond music. They're the biggest record label in existence, and you don't take this type of fight lightly. And I think that's why we're facing so much pushback here. It'll be interesting to see what happens. And I think he's going to lose his deal. Well, somebody else can give him a deal. I don't think it matters. I mean, he could get blackballed, I guess, but I mean, he's Drake. He's Drake. He's allegedly being blackballed right now, and he had a #1 album. So the machine is great at what it does. I will say that. But when you have an artist that people truly support and get behind and want to listen to, and the machine worked for so long that now people are like, when they hear this person's name, they know who they are. They want to check out their music. Drake, I keep saying this, Drake going Drake. It's not going to stop. For a brief moment in time, I imagine that this was all staged and they did this for a publicity aspect but then it got taken a little too far. This is how you know Drake didn't grow up in the hip hop culture. Y'all say that, but that's not true. But anyway, Drake won't take his L quietly. Yeah, I think y'all are missing it. I think you guys, a lot of y'all are missing the bigger picture because it was Drake versus Kendrick. The bigger picture is the business side. But it's okay. A song is the least of these dudes' worries. Drake grew up on the Family Channel. Dude ain't never been to the hood except for a photo opportunity. Oh man, I think he should have taken the L, gone with another label, then sued. Interesting point. Sony will pick him up in a heartbeat. This is Drake. UMG again. UMG paid this man nearly $500 million, y'all. I mean, you want to say what you got to say about Drake? UMG gave this man $500,000. So if they're handing out $500,000 checks, hey, let me know. All right, hey, I'll not like us either. Let me get my check. Dang. And there's a reason. It was an album. Anybody out here listen to it? Oh, we don't want to talk about who listens to what. Come on now. We got to get off the music part of it. I'm going to have to go back and read the amended complaint again. I know he amended the bots were not from UMG, but I thought he got rid of the whole payola. That's my bad. I owe you the apology. Oh no, you're good, Derek. You're good. Don't apologize. I'm playing. It's not that serious. But yeah, we're going to, so again, Derek, if you missed it, Drake already said he's going to update the complaint and they're going to have it done. When did they say? By the 16th? I don't even remember what I read. April 16th. So we'll have it by April 16th. We'll have a new amended complaint and then we can look at the details once that comes out. At this point, I'm just waiting for the court date because Drake is going to amend, then UMG is going to respond. I just want to see what happens. Oh, yeah, you know we're going to be here. I just think this might be the wrong way. Listen, two things can be true. I said Drake was lame as F for filing this lawsuit in the first place. Drake, you got to play the game. If you wanted to get involved in this game, play the game, man. Don't complain. I think it's lame that Drake brought this lawsuit in the first place. Now, that's the first part that's true. The second thing is true is from a business and legal aspect, Drake might have a point. So those two things can be true. And that's why I'm telling y'all is separate the music from it, because I'm with most of you. Drake lost and he lost bad. The Heart Part 6 was weak. Oh my gosh, it was weak. Not Like Us, huge track. I'm at my kids' baseball games, and these 8 and 9-year-olds are using Not Like Us as walk-up songs. I'm like, dang, this thing is really out there. So with that being said, you got to separate the music, got to separate the beef, and we have to focus on UMG and what part they played in this. And that's where Drake is saying he has an issue. He's like, fine, Kendrick beat me. It is what it is. But UMG used this and used Not Like Us in a malicious way. And that's where the issue comes from. Drake is an amazing artist. I wouldn't feel right saying he isn't. It's not. Anybody that says that just hates Drake. You forget Drake started with saying that K-Dot was an abuser of his wife, and that was untrue. But now he wants to call out UMG. That's crazy because dad is telling the truth, because that is telling the truth. Yeah, there were a lot of things that were said back and forth. And what I say to that is, if Kendrick wants to file a lawsuit, he can. So maybe you're right. But was that pushed and was that used by UMG to defame Drake? Did they go out of their way to say, oh man, look at this. This is a great opportunity. Yeah, we gonna get a discount now. We're giving that man 300 million instead of 500 million this time. Because look, people aren't, the culture's against him now. He decided to go up against the Prince of Hip Hop. So, hey, sorry, Drake, we're gonna push this thing and we're gonna get you on the discount. So I won't argue that. Tell K Dot to file a claim. He can do it. I like Kendrick. I'm not a diehard fan. I like Drake for a long time. I think he's trying to expose somebody he's possibly a little guilty. Expose something he's possibly a little guilty of himself. He's a lot guilty of it. Trust me. I know the music industry. Drake has benefited from this system and everything he's accusing UMG of for a long time. If he wants to say it was unknowing, fine. And in some aspect, that's probably true. But you get to a certain level. This is just how the game is played. UMG's in bed with Spotify. They're in bed with iHeartMedia. They're in bed with The Breakfast Club. They're in bed with all these different, with other record labels, Sony. It's not, let's not pretend like Drake just got it out the mud. In some cases he did, but nah, come on, man. My 5-year-old loves Squabble Up. I heard Squabble Up as a walk-up song too. I couldn't believe it. They beef, they don't want to see his side. Sorry, saying you're a PDF is way worse than saying you beat your wife in a career damaging. Let's not act slow. Well, that's true. But again, if Kendrick has an issue with it, then he can file a claim. Yeah, he can sue Drake. If Kendrick has an issue with it, just let him sue Drake and keep it moving. Anyway, let's go ahead and get into our next topic. Great conversation, though. I love having the conversations with y'all in the chat. I appreciate it. Always interesting stuff. I thought I had a picture of Yella Beezy in here. I don't think I do. I think I messed up. I don't. So whenever I don't have a picture, I have to use the Honorable Judge Whitaker, because we're going to talk about what's going on with this Yella Beezy trial that's about to go down. Oh boy. So we've got some new updates when it comes to Yella Beezy. He has been granted a bond. Yes. It's very interesting to see that a man who allegedly set up an assassination and, well, murder for hire, we'll call it, is now granted a $750,000 bond. Now, I think he has the money to be able to pay it. He's going to put some things together. We're actually going to move forward and get into the judge's decision from yesterday. And they're actually going to show some of the clips and some video we haven't seen yet here on this channel from what actually went down. We're going to hear from the defense. We're going to hear from the state and see what's going on. So check this out. Shout out to Document Tings. Absolutely amazing over on X. And a lot of the documents we use here on the channel come right from them. They have the ruling here from the judge, which came in late yesterday, showing that this man, Yella Beezy, has a $750,000 bond. All right, we're showing that here. We've got Marquise Conway. He has to appear in court. Can't use drugs, alcohol. He's got to be drug tested, alcohol tested. All right. And this was filed yesterday. So let's actually go ahead and get into the court proceedings and hear what went on and the judge's decision and why the judge made this decision as well.
To the individuals present and involved in this conversation. The state's witness will also testify to Marquise Conway, the defendant, being present and involved in this conversation. The state's witness will testify to the amount of money that was to be paid for the murder. A state's witness will testify to the individuals responsible for the payment. That state's witness will also testify that Marquise Conway was one of the individuals responsible for a portion of that payment. A state's witness will also testify to the individual who would receive this payment. The state's witness will testify that Keywan White,
murder for hire, so it's a little different,
the individual to receive this payment, who was originally indicted in State's Exhibit Number 1, the probable cause, which is before this court. The state's witness would also testify that Keywan White, or to who shot and killed Melvin Ogle. This witness would also testified to Kewan White being the individual who shot and killed Mr. Noble on November 11th of 2020. And this conversation
This
took
is
place in
state.
the days following Mr. Noble's murder. The state has also had an opportunity to review bank records of the defendant, Marquise Conway. These records would show that the defendant drew $40,000 in the days following the murder of Melvin Noble. And for the record, that was a cash withdrawal. These records would correspond to the exact amount which the state's witness would testify to. In reviewing these records, the state also became aware and believed that they would show that the defendant had anywhere between $800 and $900, but more specifically, $870,000 between a checking account and a savings account.
Jeez.
With one particular bank.
Dang, they pocket
370
watching.
Of which was in a checking account,
Oh my gosh.
a little over $500,000, which was in a savings account.
Where did it come from? Hey, let me ask y'all a question. Most of y'all in the chat and in the comments, and you're probably watching the video because you know who Yella Beezy is. But have y'all heard Yella Beezy's music or know who Yella Beezy is? This man had $500,000 in a bank account. Woo! Lordy.
The state at this time
He's out here getting it.
published to the court what's been marked as State's Exhibit number 3, which is the video of the offense. Thank you, Your Honor.
Now, before that's published, could I just address something to the prosecutor and the proffer? So it's clear for the record that as he recited, the state's witness, his proffer is, that's just one witness.
Correct, Your
not
Honor.
multiple witnesses. And that I don't recall if the specific in the proffer was when the date that this witness reported to hear this conversation.
I do not have the specific date written down, but I know it was in the days following. the
That's a
offense.
lot of moolah.
We do have evidence of when this could have taken place based off of cell phone data of when the defendant was in another state and then when he came back to Texas. So we believe we have a time frame. As far as the exact date, I do not have it this time.
Anything else, Mr. Chair?
No, Your Honor. Permission to publish, Your Honor.
Yes. You don't want the lights off?
It's at the court's discretion.
Oh.
And Your Honor, this is, just for context, this is approximately noon on I-35 heading northbound.
This video is
taken
crazy.
from a Kroger 18-wheeler, and this is heading north I-35 into downtown Dallas on noon on November 11th, 2020.
Yeah, if y'all haven't seen this video is insane. So this is a semi truck or Kroger delivery vehicle that had their dash cam on and caught everything that went down. Wild.
Now, Your Honor, if I could draw the court's attention, if you look on the, I've stopped this video at 19 seconds. You see a gold sedan in the far left lane and a black sedan in the second
Right here.
lane to the left. The gold sedan will be the vehicle carrying the victim, and the black sedan is the vehicle driven by Kewan White, who is then the shooter, based off of the evidence we have.
Look at this. You see the car swerving and it just stopped. So that's why he stopped, because the car just stopped in front of him. Look at this. Look at this. He gets out of the car. I don't know why he got out of the car. This is crazy. What are the odds of someone being right there able to capture this on camera? Insane. I mean, thank God the Kroger driver didn't get hit. I mean, if it wasn't for this, they might not have been able to catch him.
Your Honor, I'm going to stop this at 1 minute and 37 seconds. The victim does not return into the frame.
Crazy, man.
The only other things that the state would like to proffer as far as this bond hearing, since the court does not have a probable cause affidavit, of course, this is a grand jury referral.
With the semi-automatic weapon, too.
Was also indicted. You do have his murder probable cause affidavit from 2020. He was also indicted at that same time in cause number F2175377 for Dr. Randall Graham, who also sustained injuries, a neurosurgeon who was heading north on I-35 that day.
Somebody else got shot.
Struck as well.
Wow.
And finally,
So, yeah.
the last thing that I would proffer at this time would be that there were a total of 44 fire cartridge casings, all from the same style of firearm as far as the caliber that were recovered on the freeway
Ooh.
on November 11, 2020.
Y'all hear this? 44 shots. And it's amazing that only one other person got shot. Insane.
And at this time, I'm state.
It's a fact.
The defense.
Judge, this time we call Ms. Alexander to the stand.
Wild, man. Absolutely wild.
And raise your right hand, please. Do you swear or affirm that in all matters before the court, you will tell the truth, the whole truth, nothing but the truth, so help you God? You may be seated.
The judge doing it all, swearing them in.
May I proceed, Your Honor?
Yes.
Ms. Alexander, could you
Wow.
introduce yourself to the court and spell your last name for the court reporter?
Yes, my name is Alma Jean Alexander, Alexander. I'm Marquis' grandmother.
Ms. Alexander, are you currently employed?
No, I retired from Dallas County in 2014.
Now, when you tell the judge you retired from Dallas County in 2014, what was your occupation?
Deputy clerk.
And just
One
for
of
the
their
record,
own.
Deputy clerk, what does a deputy clerk do?
Process paperwork from the attorneys for the judge.
44
basically handle the
shots.
paperwork for the court.
Jeez.
And this is a building that you were employed, is that correct?
Yes, it is.
And back in the clerk's room, where in the old days, we had a lot of paperwork. Lawyers would take the file, take it back to the clerk. You would handle the file stamps and put all the papers into the file.
And type up the judgments.
Type up the judgments. Can we back up a little bit? Just tell the judge a little bit about where were you born and when did you move to Dallas County?
I was born in Washington, Arkansas. I moved to Dallas County when I was 11, so I've been here like 63 years.
And being Marquise's grandmother, could you explain the dynamics of your family as far as where are they located and how many grandchildren do you have and where does Marquise fall in the family relationship?
Okay, Marquise was my first grandson, first grandchild. I have 11
Sad, man.
grandchildren and 8 great-grands. Of course, Marquise being the first grandchild, we were always close because you're excited with your first grandchild, so you try
That's
to do
sad.
everything you can and
Dang.
instill in them good values. He's been a godsend to a lot of his family members. He helps everybody in the family. I know it's hard sometimes because when you have people pulling on you and you're just trying to stretch money, you know, it doesn't always pan out. But
Yeah, and
he's
he was on the
always
rise too.
whenever needed. He's
Let
just
me,
been.
let me interrupt you just a minute. When you say, let's just go back a little bit. Did he go to public schools here in Dallas County?
Yes, he did.
Was he born and raised here in Dallas County?
Yes, yes, he was.
And does he currently work here in Dallas County?
Yes, he's an entertainer.
Okay, and as an entertainer, so we can explain to the court, what type of entertainment does he do?
Music.
And has he done well in his music career?
Yes.
And in the music career, you have a persona, is that correct?
Yes.
Okay. And it's a persona out there for your career is different with
Super Saiyan on the stand.
Him being your grandson, did he go to church here in Dallas County?
Yes, he went to church with me often. That was one of my requirements when he'd spend the weekend.
And how often do you talk and
Shout out to
have a
Grandma.
relationship with Marquise?
When he's in town, 2 or 3 times a week. When he's out of town, sometime once a week.
His relatives, are they here in the courtroom today?
Yes.
And is his mother back there in the courtroom?
Yes, she is.
Okay, and for the record, did you just tell is that Miss Kimberly Rush?
Right.
Is his family here? Are they all here in Dallas County or Dallas-Fort Worth Metroplex?
Vicinity, yes.
Are you here to just tell the judge he has sufficient ties to this community?
Yes, he does. He does.
Now, as far as, does he have any children?
Yes, he has 2 sons,
And how old are his children?
5 and 7.
Is he, have you observed him being involved in his children's life?
Yeah, we go to football games for the little ones all the time. He's always got them in sports.
Okay, so he's out there
Good
in
job.
the community, coaching up his sons and other kids that play on the football team.
Yeah, I call him the Joe Jackson of the sports.
You call, Joe Jackson?
Hey, don't hold Grandma liable
Yeah.
now.
Joe
She did her
Jackson
best.
was Michael Jackson's father. You know how he pushed them to be great and good. So I said that's what he's trying to do with his boys.
I'm glad you cleared that up. There's other Joe Jacksons, but yes, I can get that Joe Jackson would be well involved in his family. So
Yeah.
you're telling the judge he's from Dallas County, significant ties, and he's involved with his family.
Shout out to Grandma.
As far as you're aware that he is been arrested for this charge
Yes.
of payment for hire for a murder, and this happened back in 2020. You're aware. You saw the video and you heard the prosecutor talk about
Yeah, on Facebook.
their version of the facts.
Right.
She said she saw it on Facebook. Dang.
How long has he been in jail?
Oh, 8 days since last Thursday.
The bond set at $2 million. Has he been able to post that bond and get out of jail?
He's still sitting here. No, he hasn't.
We're asking the court for a $250,000 bond based on, do you believe that Mr. Conway could post a $250,000 bond?
I'm pretty sure we can get it together.
And are you telling
And again, to mention, the bond was originally set at $2 million.
us court
In case y'all missed that.
post a $2 million bond?
No, he's not.
I don't know many people that could.
What's his nomination?
Yes, Your Honor.
Lord.
Good morning, Ms. Alexander.
Good morning.
My name is Tommy Adams. If you have any questions with my questions, if I don't form them in a good way, please just ask me to repeat myself and I will do so, okay?
Okay.
I appreciate you being down here. I'm sure this is not an easy day for you. So, thank you. You worked for the Dallas County within the clerk's office up until 2014, correct?
Correct.
Now, Ms. Alexander, are you aware that there was a bond schedule that judges could set bonds on different level offenses within this courthouse?
Yes.
And are you aware that that bond
Not the
schedule has since
offenses.
been done away with and was subject to a federal lawsuit against all the district judges within Dallas County?
No.
Okay. Now, when you talk about your grandson being an entertainer, I mean, he's more than just an entertainer, correct?
Yes.
He's in fact a double platinum artist, correct?
Right.
Now,
Killing it.
going back to 2020 and the years leading up to that, well, let me ask you this. Are you aware of your grandson owning a 2017 Denali?
Yes.
And what is that Denali, what is special about that Denali?
It's bulletproof.
It's bulletproof.
Smart man.
Now, Ms. Alexander, I can't imagine in all your years working here at the clerk's office that you ever felt like you needed a bulletproof vehicle.
I don't need one.
Now, Ms.
Smart
Alexander,
man.
Would you agree with me that in 2020 and the years leading up to 2020, that there was a lot of stuff going on in the city of Dallas surrounding, and to be quite honest, our victim Melvin Noble and your grandson Marquise Conway?
I try not to delve into Facebook and hearsay because I know him for myself. So,
Well, let me ask it this way: are you aware your grandson was shot in Plano?
yeah, I was there.
You weren't there at 3 a.m., were you?
I was at the hospital.
Correct. Okay.
Mhm.
But you would agree with me that even if you're not on Facebook, I mean, this stuff was on TMZ. I think your grandson even did an interview on TMZ with those folks on live TV about this. So you're aware
Yep.
that there was a back and forth going on in this city involving your grandson as well as Mr. Noble, the complainant in this capital murder case. You're aware of that at least, right?
Yes, somewhat.
Okay. Is that the reason your grandson felt the need to get a bulletproof Denali?
No, he felt the need because people are jealous and you don't know who's gonna do what, when or where.
Very true.
Now, are you aware of whether or not he had to, if a Denali comes that way off the lot, or if you have to actually pay money to get something like that done?
I have no idea how it happened, where it happened, why it happened. I just know he had it.
Yeah.
And as far as your grandson being in custody for approximately 8 days, defense asked you initially how long he'd been in jail and if he was able to make a $2 million bond. And your initial answer was, no, he hasn't. And then when they followed up with whether or not he could make a $2 million bond, that's when you said, no, he cannot, correct?
Right.
Now, especially with all your experience here in the county and working in the clerk's office, you're aware that when somebody has a $2 million bond, they can pay only 10% of that, correct?
Yes.
With the bondsman's help. Now, your grandson is a double platinum recording artist, correct?
Correct.
And he lives in a mansion in Frisco, correct?
Correct.
And he has houses in other states, correct?
I'm not aware of that.
Are you aware of him paying and helping to support other individuals in the family and also extended family and friends?
I'm not into his business like that.
You agree with me that your grandson is substantially well off, correct?
He might used to be, but if he could make a $2 million bond, he'd be out.
Would you agree with me though that there's a difference between can, want to, and choosing not to?
I'm aware of all of those things, but I know he don't want to be in here, so I know if he could afford it, he'd be out. Plus, he has other bills. He don't just have money laying around.
Sure. Now, Ms. Alexander, if I wanted to reach out to Ms. Rush, your daughter, what would be the best phone number to reach her at?
She's not my daughter.
Okay. Mr. Conway's mother, if I was going to reach out to her, what would be the best phone number to reach out to her at?
You don't have that information?
If you were going to reach out to her, not me.
Judge, I'm gonna object to banning
Yeah, don't-
witness and relevancy here. We're
Don't do that. Not on the internet.
getting off to getting in discovery. The state hadn't showed us their case. They made a proffer here. It seems like they can do their discovery outside the courtroom.
Objection overruled. You may proceed.
That's a super weird question.
What was it?
If you were going to call Ms. Rush, what number would you call her at? If you need to check your phone, I'd be happy to wait.
Don't put that lady's number out there.
Okay.
Oh, Lord. Judge, tell them to turn the cameras off. Dang.
Thank you.
She gonna read this lady's number for real.
214
Oh, dang.
554 5606
5-6.
06.
Judge, again, I'm gonna object to this. As
They just
far
did
as
that lady dirty.
information And getting out to the public. This is a media case. This is an improper question. I know the judge is overruling on this, but there is a fear of this getting out.
Well, it's out there now.
I would ask the court.
Your Honor, what the hell? What are they doing? Why did they just give... The judge just said it's out there now? Wow. What is going on here? This is a wild.
This getting out.
Well, it's out there now.
I would ask the court to seal the number that the prosecutor had.
It's too late.
The court's gonna overrule your objection. I do understand and appreciate the concern that it was publicly announced. So I'm going to ask, you're asking that it be sealed?
I'm asking that it be sealed from.
Just says she don't give a F.
And the court can.
Why, Judge? Why?
For this bond hearing, and that this not be published outside of the courtroom, the media sitting outside.
It's too late.
And I think there's a legitimate fear base here.
It's
just
too
like
late.
The state has their concerns, so that was my objection.
The court will grant that objection.
To
Sustain
sealing?
that objection. You can use it for your purposes only, it cannot be published to anyone else.
Okay, sure. And Your Honor, the reason I'm asking, I'm going to have another question too,
Go
is
ahead.
that in State's Exhibit number 6, which is the confidential affidavit of financial conditions, in which the defendant.
Yes, that is Black Judge.
The contact number, the only emergency contact person he lists is himself.
That's crazy.
And so, and the problem with that is that number that he listed for himself is according to Ms. Alexander, the same number. So I'm just trying to clear some things up. We don't have anything on the information here.
All right, thank you.
Thank you, Your Honor. And Ms. Alexander, my follow-up to you is that if you were going to call your grandson 8 days ago, what number would you call him at? And if the defense wants this portion to be sealed, I'm fine with that too, but I think this is important information, Your Honor.
Well, could we have a write it down, perhaps?
That's fine.
There you go. Y'all said it. Can't you write it down? God dang. They just doxed the hell out of that lady. That's crazy. Said, can we write it down? I mean, man. I can't believe they just read that lady's number out like that. Wild.
Thank you, ma'am. Senator, the defense looks more of State's Exhibit for side.
Okay.
Crazy.
7 is admitted.
Absolutely insane. She for real said, it's out there now.
Your grandson has significant ties to this community, correct?
Yes,
Born and raised in the greater Dallas area.
correct.
As far as how much time he spends in the city of Dallas, or more or less Dallas County and the surrounding areas at this point, do you know approximately how much time he spends in the greater Dallas area per month?
I'd say 3/4 of the time.
3/4 of the time.
This is crazy. Shout out to Dottie in here.
Now, just as far as his ability to travel and nature of that, like planes and getting around, you're aware that he travels quite a bit via private jet, commercial, all of that, correct?
Yes.
Does he have access to his own private jet?
No.
I was about to say, this man got a private jet. He might be in trouble. I'm sure he talked about it in the
Do you
song,
know
though.
approximately how often he does fly private?
No, I don't.
But when he does that, he would be having to pay for those bills as well, correct?
Correct.
Do you agree with me that flying private is not the cheapest thing in the world to do?
Yes.
No further from State Law.
Anything else from this witness?
No further questions, Your Honor.
All right, thank you, ma'am. You can step down.
That's
Any other
insane.
witness?
Judge, I was going to make a proffer we discussed back in Chambers. May I make a proffer, Your Honor?
Yes.
Judge, a lot of us have been down here at this courthouse for 30 years. I'm not going to go over the law. I know you understand the bail bond and how we have a new law. I just wanted to point out in some of these cases where there's high profile, in the state versus Michael Lucky, that was a capital murder case. That was in criminal district court number 7, the court that we're in. That was a high profile case. That case involved an NBA player that was initially set by the
NBA player.
in jail with a probable cause affidavit, where they had knowledge of the facts from what the police said. And that bond was originally set at $500,000. It was later reduced by the court to $100,000 with conditions. Co-defendant in that case, Larry Jenkins, cause number F2076397.
Larry Jenkins, that gotta be the blackest name I ever heard.
Where the magistrate with a probable cause affidavit set it for $750,000.
Larry
case,
Jenkins.
State of Texas versus Antoine Franklin, capital murder case, 522-76141. This involved a famous football player out of Oklahoma. That case was set by the magistrate for $500,000. Again,
Way more money than a rapper.
he was later reduced by the court to $200,000. Judge, in dealing with the bond schedule, you have bond conditions here that require electronic monitor. They have several conditions of probation, check-in, and curfews. We're proffering to the court here that the court has set bonds down here in Dallas County where the typical murders range between $150,000 and $200,000, and a capital murder can range, in these cases, in between $500,000 and $750,000, where the magistrate set them. The thing in this case that we're proffering, the magistrate had no probable cause affidavit. They had no facts, and in this case, we're asking the bond to be reduced in these facts. We'll argue here, but I just want to proffer those three cases.
All right, anything else?
Interesting.
We'd just like to argue.
Okay, state.
Your Honor, I would just, if I could, just briefly, I would also like to proffer just two cases since defense has brought up some cases that have come here from Dallas County. The first one I would like to bring up is F2475475. Defendant's name is Chaz Booth out of the 194th Judicial District Court. He's currently sitting in jail on a capital murder charge for $2 million. That defendant is not a celebrity, a basketball player, a football player, a musician, an artist, or anything like that.
Okay, what's the bond on that one?
$2 million.
Oh, $2 million.
He's a
Yeah, but it's not murder for hire. That's different.
20-year-old who is charged with capital murder. Additionally, we have Jordan Owens, who was recently sentenced F2377243, also a capital murder, and his bond was set at $1.5 million, and I believe that was in the 282nd Judicial District Court.
Talk to him, Shadow Fox.
I'm not going to go back and forth, so that's all we have as far as rebuttal and withdraw.
Your arguments?
We'll waive and reserve the right for rebuttal.
All right.
Judge, I'll begin and then Mr. Gusti will finish up. Your Honor, as you know, under 1715, the court considers certain facts in the bond reduction hearing and determining whether to reduce the bond. Here in this hearing, the court has before you introduced two arrest affidavits. There is not the arrest affidavit of our client, that does not exist, but you do and have reviewed the arrest affidavits of Kewan White and Mr. Brown. Those arrest affidavits were taken on Kewan White was December 8, 2020, Devin Brown.
That's the alleged shooter.
2021. The offense itself is approximately 4 years and 4 months ago when it occurred. We carefully reviewed those affidavits and set out how the offense, and we saw the video. Nowhere in those affidavits is there any mention of our client, any mention of his role, any mention of connection to this case in either one of those affidavits that you have before you that you can consider. As far as the proffer given by the state, they choose what they can proffer. They said they have one person who overheard a conversation after the incident that happened on the highway in which he heard money being discussed.
Oh, dang.
Client present at that during that conversation about paying money. You received no information in the proffer as to the credibility of that witness, if they have a bias or a motive for coming forward. Now, at this time, 4 years, 4 months later.
So we talking about snitches.
We have you don't even have a proffer that this was a confidential informant, which you know requires some type of vetting. Just that it's a person who said they were present during this one.
Who do y'all think was talking?
And that's the only evidence that you have before you this hearing that connects them to this offense. The state also proffered a bank record that said there was after the incident in November of 2020, there was a withdrawal of $40,000 cash. No proffer was made as to if that money there was traced anywhere to the other defendants charged in this offense. You received no information of a text message, any message on social media platform that our client
That part,
paid for
Michi.
this murder, any type of remuneration, no recording of any sort, just this person who came forward and said he overheard this conversation. As far as the bank records go, the only thing in evidence before the court are records that were back in 2020 when they quoted two different accounts which accounted for $800,000. You heard no evidence as to his current financial bank records and what is in there. You only had before you testimony of the defendant's grandmother who told you he cannot make the bond, has not been able to make the bond, and cannot make the $2 million bond. I'll let Mr. Beezy finish with the other parts of the argument.
It's a great point.
Thank you. I'm not going to go back over what Mr. Shook said. What the court has before you is a case that's been investigated for 5 years, and my client, Conway, is a citizen in this community that has no flight issues. He has not left his community.
What about his record? What is his
family is
criminal
sitting right
record?
back here in the courtroom that showed up to the support in this community. A big factor of this is that he has significant ties to this community. The current bond conditions that you have in place with a leg monitor would be whatever concerns that the state may have or the court may have to know where he is. His grandmother.
Y'all want to know something crazy? You know, you want to know something I just thought about, and y'all hate it when I do this, but I got to do it anyway. Going back to the YSL RICO trial, this man who has been, in some opinions, convincingly connected to a murder for hire, got a $2 million bond, no questions asked. Young Thug, who was alleged to have made some phone calls, maybe murder for hire wasn't even one of the charges, got no bond, no violent criminal history, never a felony conviction. Is this man crazy?
Has worked down here and understands how to communicate with the court. We have people, and the bond restrictions of that, the court is aware of how significant the bond restrictions are in keeping them.
Sat in jail for 2 years.
Judge, we're coming at this this is a significant oppressive and punitive
Man.
and under the law, in our opinion.
Law is so messed up.
The magistrate, when she set this bond,
And yet Gotti's still in
did not have
prison.
any evidence in front of her and set it high. We also believe that after 8 days, had he had the money, he would have posted it, and he's sitting here in jail. And that those cases that the state and I have talked about, the court is well aware of a wide range you have. But given these facts that Mr. Shook went over with no corroboration, we don't know anything about their case, this witness, who they are, the court doesn't. And given the facts presented, we're asking you to reduce this bond to an appropriate amount where he can abide by the conditions and come to court and we can fight this case.
Okay, thank you. State.
Yeah, sure, just briefly. In regards to an individual's ability to pay the bond, Ms. Alexander testified specifically that she is not involved in her grandson's business and doesn't keep up with his financial stuff. So she really was not in a position to testify what he can and what he cannot afford. She did testify to the fact that he is a double platinum, I believe as of recently 2 weeks ago, recording artist, that he travels about a quarter of the month, that he lives in a mansion in Frisco, that he drives a Denali, a bulletproof Denali, which also will lead into safety concerns. So the only thing that the court has as far as ability to pay or not to do it, or not having an ability to pay this bond, is the bank records, which I proffered to the court, as well as his own grandmother saying that he's a successful artist.
Bro, what are you talking about? $500,000 is not $2 million, bro. Get out of here.
Up in Frisco, that flies on private jets and travels.
He's saying get the record label and pay for it.
It's not just the fact of the cost and all of that, but it's the fact that when we're talking about safety concerns for the community, one of the factors that the court should take into consideration is if this individual were to get out, is there a viable safety concern? The fact that the defendant has a bulletproof vehicle and drove one at the time and was arrested in it 8 days ago, that should tell you all you need to know. And that's not just based off of pure jealousy. Your Honor has been doing this long enough to know that is based off of something much greater than just pure jealousy.
So you have a bulletproof vehicle, and that means that you're a threat to the community? Oh man, we got another. These prosecutors, I don't know where they get these people from. If y'all want to know if Yella Beezy had any other previous charges, we have October 2018. That's when he got shot. He was shot multiple times while driving in Louisville, Texas. He was hospitalized. Obviously wasn't charged there. February 21st, he was arrested in Dallas for unlawful carrying of a weapon and possession of marijuana. Those charges were dismissed. August the same year, he faced another arrest on charges of unlawful carrying of a weapon and possession of marijuana. So he might have been charged there. I would have to look up the exact article to see, just to make sure. November of that same year, he was arrested in Plano, Texas on charges of assault of a certain nature. Y'all can use your imagination, and child endangerment. These charges were subsequently dismissed. And then, of course, we have the charges that we have here. So it seems like some minor things, but nothing criminal.
As far as safety
and nothing violent
for the community, this is, as defense has stated, a very high-profile case, and this defendant is very well known, not only locally, not only in the state, but nationally and internationally. The fact that this individual has the means and the resources and the reach to get to witnesses is a true concern that the court should also take into consideration, and that this was part of a bigger thing that was going on in 2016, 17, 18, 19, 20, culminating in the death of Melvin Noble. The circumstances surrounding it are not only the offense in itself, but the circumstances building up to Mr. Noble's death. And Your Honor, I didn't want to go back and forth with the defense on proffering cases of bonds and $2 million and $3 million bonds, but the truth is, this is a capital murder for remuneration. And the defendant is charged with paying other individuals to take another human life.
So take all his money.
Means and the reach to do it. In fact, I think it's important that there was another victim. This was at noon on I-35 leading into downtown Dallas.
But he's not the shooter.
Cartridge casings. Who knows how many others were knocked away by the cars that kept driving by. Melvin Noble was hunted down on November 11th in 2020, a beloved son of Dallas. It could have been so much worse, and that's a terrible thing to say when it's a capital murder for remuneration, where he has paid another man to hunt down and kill somebody in broad daylight. Your Honor, based off of all the testimony and the facts that have been presented in this court, we'd ask that you leave the bond where it is at, currently at $2 million.
All right, let me have the exhibits, and then if you all will give me about 10 minutes, I'll respond.
Got it, Your Honor.
Yes. The defense did not have any exhibits, right?
No, Your Honor.
And this is just the video, right? That
Yes,
we're
Your Honor.
releasing. Anything else that I need to take with me?
And we had 1 and 2 still.
Yeah, that's it.
Change.
All right, thanks.
All right.
All right, so the judge is going to take a break, make her decision, and then let's see when she comes back what she says. We already know the number, but we want to hear it from her.
Okay, the court, is the court ready? Yes, Judge. All right, the court's ready to make my ruling. The court is going to reduce the bond to $750,000. The court
Light
took into
work.
Consideration, certainly, the biggest consideration was the offense, the severity of this particular offense. It's pretty egregious to watch. That
But he
video.
didn't do it, Your Honor.
But the court also took into consideration the evidence or lack of evidence that the state presented. That was a factor also. Another concern I had was the financial statement that the defendant was to put on file. He didn't seem to take that very seriously at all. And that causes me concern about whether or not he's taking seriously the allegations against him. So I am going to set the bond at $750,000 with the bond conditions that were already set. But included on that, I want it to be very clear, Mr. Conway, that you are to have no contact, direct or indirect, no threatening or harassment of any victim, witness, co-defendant. If it's you or anybody on your behalf, there's going to be a problem. Do you understand that? Okay, you all can stand. I'm talking to you now.
So, yeah, so no diss tracks while you out on bond, my friend. All right, just let it go.
So that's going to be a concern. And then I want to make sure that you provide the court with correct information regarding your person of contact, because basically,
Interesting.
affidavit seemed to be your way of saying, forget y'all. I don't want you opening your mouth. Yeah. Seemed to be your way of saying, forget y'all. So you need to provide.
She said, I don't want you to
correct,
open your mouth.
Accurate information regarding who is your person of contact should there be any type of problem. I hope that you're taking this seriously because your responses in this affidavit kind of indicate that you're not. You understand me?
Yes, ma'am.
Okay. Is there anything else?
No, you can say, Your Honor.
Anything else from the defense?
No, Your Honor.
All right. Thank you.
Thank you, Judge.
There it is. So Yella Beezy, he about to get out. Y'all think, what do y'all think the role he had in this was? Do you think he was actually the one that set this all up? Was it that serious? Or was he just wrong place, wrong time? And we got Mr. White in there singing like crazy, just trying to find a way to get a plea deal. I don't know. I'll be looking forward to seeing the evidence come out. Y'all know we're going to cover it here. Let me know what you think in the comments and in the chat. All right, y'all. We got one more we got to get to. I was going to skip past this, but I got to cover this, man. Since it's Friday, I won't get to see y'all all weekend. But shout out to Amy dropping the super sticker. I see you over there, Amy, getting the cake ready. Oh, man, let me get some of that cake, please. It's past lunchtime, too. Amy knows. She knows what's up. Shout out to Amy here with the super sticker. And Dottie as well stopped by to say she got an A on her math test. Look at that. Congratulations, Dottie. Amazing Grace is in the building. 100% a setup. Ow. Dang. Michi, I thought that from day one. It's crazy, though, says Dylan. Them giving capital murder suspects bond, not saying he's guilty, but I've seen it a lot lately. Usually that's the one charge you don't get a bond for in the most part. Texas is a little bit different. Judge said no drilling. Yeah, I want to see the evidence too. No phone call data. No phone call data. If talking crazy ex-friend was shot and killed, they got him. We're going to see it all play out. I don't think they're going to take too much time getting to this trial. So we might have a trial in the next 60, 90 days. What do y'all think? Very suspicious, you're saying? This is going to be interesting. I agree. I want to see the evidence come out. I want to see what actually happened, what went down, what conversations were had, because this is going to be an interesting one. All right, we got one more thing we're going to get to. We got an update with what's going on with Big U up in there. Mr. Eugene Henley's in the building. And when it comes to the Big U indictment, we got to see what was going on and read into a little bit what the police saw during their investigation. And, you know, we had everybody in there. We had the FBI. We had, so many people, the LAPD involved in this Big U investigation. But now we're hearing that the indictment is going to be unsealed. We heard from the judge last week. The judge was saying, no, we're going to keep things open for now unless we have any issues moving forward. So now we're going to get to see what these 43 indictments are. It's our 43 counts, I should say, are. Now check this out.
A music executive and alleged LA gang leader Eugene Henley Jr. has just been named in a 43-count federal criminal indictment. Prosecutors accuse Henley of racketeering, fraud, extortion, and embezzlement.
Dang.
Henley surrendered to authorities last week in connection with a federal complaint linking him to the 2021 killing of an aspiring rapper. Prosecutors say that Henley, also known as Big U, has ties to the notorious Rollin' 60s street gang. His arraignment is
He has some
scheduled for
deep
April
ties.
8th.
All right, so they've got the arraignment on April 8th. Unfortunately, we're not going to be able to see that. Y'all know this is a federal case, but the Tribune here actually gives us some more insight into what is going on with this actual indictment. Big U faces 43 count federal indictment in this RICO case tied to Rolling 60s, Crip, and wire fraud. Eugene Big U Henley, a prominent name in hip hop and former subject of Fox's Hip Hop Uncovered, is now at the center of a sweeping federal investigation. On March 19th, Henley was taken into custody in LA, and days later, prosecutors unsealed a massive 43 count indictment against him, Lord, detailing the allegations of racketeering, fraud, extortion, and much more. As the indictment alleges, Mr. Henley led a criminal enterprise whose conduct ranged from murder to sophisticated fraud that included stealing from taxpayers and a charity. Diabolical. Don't know why this skipped ahead. My bad. Said acting United States. Oh, this is trying to play. Here we go. Said acting United States Attorney Joseph McNally in a press release. Eradicating gangs and organized crime is the Department of Justice's top priority. Today's charges against the leadership of this criminal outfit will make our neighborhoods in Los Angeles safer. The indictment claims Henley ran an operation called the Big U Enterprise, using his influence within the Rolling 60s, Crips, and other gangs to orchestrate crimes across LA. The group is accused of being involved in murder, extortion, robbery, trafficking, wire fraud, illegal gambling, and embezzlement. Prosecutors say Henley and his associates, Sylvester Robinson, Mark Martin, Tremaine Ashley Williams, Armani, because I can mess up the last name, Frederick Blanton, and Tiffany, I don't know why it's doing that. Sorry, y'all. And Tiffany Hines are all currently in federal custody. Henley's charges include conspiracy to violate the RICO Act, multiple counts of Hobbs Act robbery and extortion, attempted extortion, transportation of an individual across state lines for prostitution, wire fraud, embezzlement, or other federal funds, bank funds, tax evasion, and failure to file tax returns. This guy's a mess. Authorities allege that this operation not only targeted businesses and individuals, but also misused funds from organizations receiving government support. This case marks a dramatic fall from grace for Henley, who in recent years had built a public image centered around mentorship, anti-violence work, and community development. The indictment, however, suggests a far more sinister narrative unfolding behind the scenes. Henley is scheduled to be arraigned on April 8th in LA. If convicted on all counts, he could face decades behind bars. All right, so now we're going to go and hear from an attorney who says what they saw in these 43 counts against Big U. Here we go.
3 counts. This seems different than what we heard a couple weeks ago of 16 people arrested and charged as part of a different gang indictment. Here, what they're saying is the Big U Enterprise, along with his 5 associates, yes, Termaine Ashley Williams, aka Loose Cannon, is alleged to be part of this enterprise. He's part of the robbery angle. There's a lot of charges. Let me take you through the primary charges. The first, the Fed's favorite, it's a criminal RICO enterprise. What are they involved in? Robbery and extortion. I don't know if you've heard anything about Big U and his cohorts extorting people, but the Fed seem to think that what you may have heard is true. There's transportation for prostitution. There's bank and wire fraud. You have tax crimes, obstruction of justice. Now, there's a number of different schemes that they're saying the Big U Enterprise engaged in. One of them, you've probably heard of it, is the check-in extortion scheme. You're an out-of-town celebrity or a gang member, and you want to come to L.A., well, you better get permission from Henley, according to the feds, because a failure to check in will result in robberies, assaults, or worse. They reference that the Check-In podcast, I haven't seen it, I don't know if you've seen it, please direct me to the Check-In podcast, was used to legitimize this practice. The other charge, the murder of a rapper in Las Vegas. R.W., the rapper, was with Unique Music and allegedly murdered by Henley after perceived disrespect. The feds say they have surveillance, cell phone
Allegedly.
data, and family interviews that all point to Henley as being the last person seen with RW, the murdered rapper. And they say that there was an alleged cover-up where Henley and his associates went into the studio and got the surveillance tapes right before the murder happened. There's armed robbery of a marijuana dispensary. Henley allegedly ordered the robbery of a dispensary where an extortion victim worked.
The
After the
Check-In
robbery,
podcast
the
is
victim was
crazy.
invited to Henley's home and told, "That's how you rob yourself." There's allegations of ongoing robberies and threats by loose cannon. They say they allege that Williams continued violent behavior, including a recent pistol whipping that was caught on video. Then there's
Dang.
extortion of business owners. Victims were extorted for thousands per month with threats of violence or robbery if they did not comply. There's a human trafficking and a sex trafficking allegation where Henley paid people to transport women across state lines for prostitution. The feds say they've intercepted communications showing explicit instructions and references to sex work. There's fraud and embezzlement. They're saying that Henley used his nonprofit called Developing Options to fraudulently obtain grants. I think they're talking about PPP fraud or other COVID-19
Seen
related
that a lot.
loans. There was the EIDL loan. And allegedly, he used fraud to obtain this stuff because he lied on the applications about what the enterprise,
talked
what the
about that.
business actually did and who its employees were and how they were going to use the money. Then a nice little ending is, hey, after we announced the charges against him, he went online using somebody else's Instagram account. He got rid of his phones, stopped using them, and then went on somebody else's Instagram account and said, yo, my co-defendants, don't talk to them. They're losers. They're doing wrong. The feds seem to think that this guy was at the center of a criminal organization that's been running from 2010 to 2025. There's a probable cause affidavit. They said they've gotten
Wow.
all types of search warrants and subpoena returns in support of all of these crimes. The big question that I have that I can't understand is why are there only 6 people in this indictment? And then a couple of weeks ago, we got word of 16 that were rounded up and arrested as part of a RICO enterprise. Stay tuned. 3 counts. This
Absolutely wild, absolutely insane. I've got one more thing I want to cover with y'all, and then we'll keep it moving. Megan Cuniff over on X posted this as well, talking about the 43 count indictment, and we've got this statement here, and she says feds in LA today announced a new 43 count indictment against the Rolling 60s Crip gangster Big U. Henley was arrested last week, obviously, and then mentioned the arraignment. So I'll just read the first instance, this first couple paragraphs, to see what they say. A federal grand jury has returned a 43 count indictment charging a music label owner and purported anti-gang activist who is a longtime leader of South Los Angeles street gang with dozens of felonies, including fraud, robbery, extortion, tax evasion, embezzlement of donations to his charity that receives public money, and running a racketeering conspiracy in which he allegedly murdered an aspiring musician, the Justice Department announced today. Dang. Eugene Henley Jr., a.k.a. Big U, of Hyde Park neighborhood of Los Angeles, is charged with 1 count of conspiracy to violate RICO, we know, 2 counts of conspiracy to interfere with commerce by robbery and extortion, 1 count of Hobbs Act robbery, 9 counts of attempted robbery and extortion. Oh my gosh. 5 counts of Hobbs Act extortion, 1 count of transportation of an individual in interstate commerce with the intent to engage in prostitution, 15 counts of wire fraud, 5 counts of embezzlement, conversion, and intentional misapplication of funds from an organization receiving federal funds, 1 count of bank fraud, 1 count of tax evasion, and 2 counts of willful failure to file a tax return. Oh my gosh. Not looking great. I don't know what else to say on this. Big U, I mean, innocent until proven guilty. We're going to have to wait and see what the evidence shows. But it's not looking good for you, man. Y'all let me know what you think in the comments and in the chat. 15 counts of wire fraud. Oh my gosh. That's tough. All right. Shout out to the gang. I appreciate y'all. Why would criminals go on a podcast and admit to unproven crimes? Gigi Lynn is in here. What's up? What's up? Good to see you. I don't get it. Why these guys run to the internet and just say, hey guys, this is what happened. Have a podcast called Check In Podcast. They just think they're invincible. Oh man, a lot of people were taking those PPP loans and taking them illegally. Once he stole that government money, it was over. Right? Can't be stealing from them folks. I worked at a bank during the PPP loan era. That amount of fraud that happened was actually tiring. Yeah. Yeah, and a lot of people are getting caught up for that too. All right, y'all, I'm gonna let you get out of here. Hope y'all have a great rest of your afternoon. Thank you for kicking it with us on today's show. Y'all know we're gonna be back here Monday with some more breaking news, some more exclusive news, and hopefully some updates on what's going on with these cases we've been covering. Oh, Karen Reed trial starts next week. We're going to be covering that here on the channel. I'll be dropping some clips from the trial as well. So make sure y'all stay locked in and tuned in for that. If you haven't yet subscribed, hit the notification bell so you don't miss any time we go live or drop a new video. Hope y'all have a great rest of your afternoon, a great weekend. And as always, you know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace, y'all.